All right, take two. Apologies, we were muted for that. Good morning, everyone. This is our final captions check for our live stream. We're about to get started here shortly. If you heard the message in the room, if you'd please push the button to turn on the light to make sure the microphone is working. And before you leave the podium, to push the button to make sure it is off when you leave. For those online, if there are any public comments or anyone who is addressing us online, please make sure that you are also unmuted and give about a 5-second buffer for the internet to catch up so that we can hear you in the room and confirm before you begin speaking. Thank you.
All right, good morning, y'all. We're about to get started. Good morning and welcome to the February 13th, 2025 meeting of the Texas Commission on Environmental Quality. It is, I have my glasses today, so this is beneficial, 9:38 a.m. I'm joined by my colleagues, Commissioner Janeka and Commissioner Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. And Garrett, I'm not going to forget OPIC today at all. For each item that argument or discussion is allowed, we will inform parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table with our very nice ladies. If you are here in person or if you are on the webinar, email agenda@tcaq.texas.gov with your name, affiliation, and the item you would like to comment on. We'll absolutely do our best to accommodate that request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking. And please check to make sure your line is unmuted before proceeding. With that, I'd also like to congratulate our winners of our chili contest that we were at yesterday at headquarters. We had over 50 entries for chili, and I got to taste most of them with Commissioner Janeka. Some were exotic and some were very, very normal chili, but exceptional turnout and really, really fun to meet everyone. I will tell you, after sampling all of that chili, going to 3 Senate meetings in a row right after was not ideal, but totally worth it. So congratulations to the winners, and I cannot wait to enter next year. So get prepared. Greek chili, man, it's coming.
I appreciate you recognizing that, and I add my kudos to those agency staff and employees and family members who all showed up and participated. Commissioner Gonzalez last year participated. It was the first commissioner I ever saw cooking and participating in the contest. So I'll let her speak to that. But the chili brings out the passion and arguments in people in fun ways. The no beans debate, obviously, I won't touch that. But the lively argument I saw yesterday over whether chili could be vegan or not because it tasted too much like cheese. So it was a great, our employees are really wonderful people, and I enjoyed getting to see so many of them yesterday.
Yes, I last year, I didn't formally enter, I just provided chili because, you know, even if my chili was the one that would dominate the competition, I didn't want the stain of, you know, people voting for me just because I was a commissioner. So on my definite victory that would have occurred.
Well, maybe we just do mano next chili cook-off and see.
Yeah, I'm willing to take that on.
Let's do it.
Feel good about my chili.
Anyways, again, thanks to the staff. It was a really great event, and I was happy to be there. And with that, Ms. Smith, let's call the first item.
Item number 1 is the application by Space Exploration Technologies Corporation for new TPDES permit number WQ 000546200. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Well, thank you very much. This is quite a big deal before the commission. Before our consideration is an application by Space Exploration Technologies Corp. For a new TPDES permit to authorize the discharge of deluge water used for launch and return to launch site activities, facility washdown water, and storm water for intermittent and flow variable basis. We've received a number of hearing requests filed by groups and individuals raising concerns about impacts, particularly to their health, recreation, and religious activities. In my review, I find that based on the parameters of the discharge and the intervening distance between the discharge and the requestor's religious and recreational activities, the hearing requesters did not show that their ability to practice their religion or engage in recreational activities will be affected in a manner different than the general public. Turning to the request for reconsideration filed in this manner, I do not find that the requesters identified new factual information or an error that would alter the executive director's decision. So in conclusion, I would deny all the hearing requests and RFRs and issue the permit. Colleagues, what say you?
I reached the same agreement.
When I was looking at this, I take protection of religious freedom very seriously. And so we also did a deep dive on the more comprehensive look at the law on religious freedom impacts, because this interest does not come before us very often. And looking closely at the facts of this matter, given the nature of the discharge and the considerable distance from the requester's religious activities, I don't believe that the hearing requesters have shown that their ability to practice their religion will be affected. Similarly, those who articulated concerns for their recreation are, to my mind, too far from this discharge to be affected in a manner different than the general public. So I would also deny these hearing requests and issue the permit.
Well, thank you, Commissioner Gonzalez, for your work on that and your deep dive. I appreciate it very much. I've also reviewed the executive director's response to comments and would propose that we adopt that document. Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, adopt the executive director's response to comments, and issue the draft permit as recommended by the executive director.
A second? All those in favor?
Aye.
The motion passes. Thank you very much.
Ms. Sheriff, if I could just for a moment though, I just want to thank the staff as well for their work on this permit. This is an unusual one. We don't see this sort of thing all the time. And with innovation, our staff also has to innovate. And I think they did a fantastic job doing this. And I think that's also highlights one of the great things about doing business in Texas. I think if this was any other state, we would be probably permit would be far behind. So,
Well, thank you. I echo that sentiment. Kudos to the staff. So thank you. Let's move to item number 2, please.
Item number 2 is the application by Wolf Hollow 2 Power LLC for air quality permits numbers 175173, PSDTX 1636, and GHG PSDTX 238. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Well, good morning, y'all. Thank y'all for being here. I very much appreciate it. The permit before us would authorize the construction of a new power generation facilities that will expand the existing Wolf Hollow 2 power plant. We received numerous hearing requests on this matter. For hearing requests, we use the same 2-part analysis as described in the last item. Let's talk about effectiveness, which determines who has a right to a hearing. The requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file both timely comments and a hearing request that identify both their personal interests and the concerns that they have. Finally, the identifiable concerns must be within the commission's jurisdiction to address in the authorization. I want to begin by saying that most of the hearing requesters filed a form letter that provided space for the requestors to write in the reasons why they were opposed to the permit. While many of the requesters left that part blank, other requesters included additional language that expressed their concerns with the permit. Additionally, several requesters signed a petition expressing the general concerns related to the proposed facility. I believe that the following requestors have satisfied the statutory and regulatory requirements for being considered an affected person. Shanice and Travis Koppenhaver, Daniel Lackey, Karen Person, and Cheryl Shadden. Based on the issues raised by these requesters and their proximity to the proposed facility, I believe that they have shown that they may be personally affected by this application in a manner not common to the general public. For the remaining hearing requests, I would recommend that we deny those requests because they either did not file timely comments or failed to identify a personal justiciable interest related to the proposed facility. I'll stop there to see where you landed on effectiveness, Commissioner Janeka and Commissioner Gonzalez.
I'm in agreement with you.
Also in agreement.
Thank you very much. Moving to the second part of our analysis on the issues, affected persons raised relevant and material issues concerning whether the draft permit will be protective of the requester's health and the health of their families, animals, and livestock, and whether the draft permit will be protective of air quality. These issues are within our jurisdiction to consider for an air permit application, so I'd recommend that we send these issues to SOA. I would also recommend denying all requests for reconsideration. I do not believe they raise new relevant and material information for the commission to consider. And finally, I'd recommend a 180-day hearing duration. Colleagues?
I'm in agreement.
I move that we grant the hearing requests of Shanice and Travis Copenhaver, Daniel Leckie, Karen Pearson, and Cheryl Shadden, and that we deny the remaining hearing requests and all requests for reconsideration, that we refer the application to SOA for a contested case hearing on the following issues: whether the draft permit will be protective of the health of the requesters, their families, their animals and livestock and wildlife, and whether the draft permit will be protective of air quality, and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
A second.
All those in favor say aye.
Aye.
The motion passes. Thank y'all very much. Appreciate y'all. I'll let people move around, but let's get to item 3.
Item 3 is the application by Quadvest LP for new TPDES permit number WQ0016143001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
All right. Well, thank you. Before us, we have an application for a new TPDES permit that would discharge up to 500,000 gallons per day of treated domestic wastewater in the final phase. For these types of applications, the commission considers a 2-step analysis. First, we determine whether a hearing requester is an affected person. If there are affected hearing requesters, then we consider whether an affected person raised issues in their hearing requests that are referable to SOA. The commission received one timely hearing request from a Mr. Robert Humphrey. To be considered an affected person, the requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file timely comments in a hearing request that identify both their personal interests and concerns that they have. Finally, the identified concerns must be within the commission's jurisdiction to address in the authorization. Turning to Mr. Humphrey, I do not believe that we should grant his hearing request. The only issue he raised was the characterization of the discharge route, which he argues was incorrectly represented in the proposed permit when originally noticed. In response to this comment, the applicant corrected the discharge route. The ED reevaluated the application based on the corrected discharge route, and the application and draft permit were reissued and renoticed based on the revised discharge route. Mr. Humphrey identified no other concern or explained how the permit might impact him or his property. Therefore, I do not believe he established a personal interest to qualify as an affected person. Commissioners?
I agree. I didn't find any requests in Mr. Humphrey's hearing request raising concerns for his health, safety, or use of his property, so I find no basis for finding him as an affected party.
I'm in agreement.
Thank you. Is there a motion?
Apologies, I flipped screens. I move that we deny the hearing request of Robert Humphrey, issue TPDES permit number WQ0016143001 to Quadvest LP as recommended by the executive director, and adopt the executive director's response to comments.
A second?
All those in favor say aye.
Aye.
Motion passes. Thank you very much. All right, Miss Mary, let's go to 4, please.
Item number 4 is the consideration of the application by Cielo Gardens LP for new TPDES permit number WQ0016374001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Thank you, Mary. Before us, we have an application for a new TPDES permit that would discharge up to an average flow of 900,000 gallons per day of treated domestic wastewater in the final phase. Again, for these types of applications, the commission considers a two-step analysis that begins whether a hearing requester is an affected person. In this matter, the commission received one timely hearing request from Jane and Roy Besant. The Besants filed timely comments in a hearing request that identified their concern with water quality as a result of the proposed discharge. The Besants are located approximately half a mile from the discharge point, and the discharge route flows through their property. I agree with the ED and OPIC that we should grant the Besants hearing requests, taking into consideration the proposed volume of the discharge, the issue that these individuals raise in their hearing requests, and their proximity to the proposed discharge point and the discharge route. I believe that they have shown that they may be personally affected by this application in a manner that is not common to the general public. I'll stop there to see where y'all have landed on effectiveness.
Well described, and I'm in agreement.
I'm in agreement.
Moving to the second part of our analysis on the issues, the Besants raised concerns about water quality and the discharge potential effect on wildlife. This is relevant and material issue that the commission routinely refers to SOA. What do you think, Bobby?
I agree, and I think the single issue addressing the wildlife under our Texas Surface Water Quality Standards that we typically refer to SOA is appropriate.
Okay. Katarina?
I'm in agreement.
Well, finally, I'd recommend a 180-day hearing duration, as well as a referral to our ADR program. If we're all in agreement, I'll entertain a motion.
I move that we grant the hearing requests of Jane Besant and Roy Besant Jr., that we refer the application to SOA for a contested case hearing on the following issue: whether the draft permit is protective of water quality, livestock, vegetation, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and we set a maximum hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you very much. All right, Mary, let's go to item 5, please.
Item number 5 is the consideration of gifts and donations of $500 or more in value given to the TCEQ and submitted for approval in accordance with Chapter 575 of the Government Code concerning acceptance of gifts and donations. And the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yan Chen of the General Law Division, representing the Executive Director. Before you are the gifts and donations the agency has received in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have regarding these items.
Any questions, comments? Mary, has anyone signed on this item?
No one signed in.
All right, Garrett?
Good morning, Chairwoman, and good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by the ED.
Thank you very much. I reviewed the gifts and donations in this report and believe that they should be acknowledged and accepted. I'd like to thank those who provided these travel opportunities to agency staff. And I'd like to thank HEB, of course, for their donation to our Take Care of Texas program. I'm ready to proceed with approving the issuance of the ED's resolution. Colleagues?
Thank you, Madam Chair. I echo your sentiments and just wanted to also acknowledge HEB in particular for the large gift that's getting caught in this particular report. I appreciate your eyes bringing your awareness and context from working at the board to also reviewing these gifts and donations here. So doubly glad to hear you're pleased with what's before us. I'm always generally pleased. Thanks.
Thank you.
HEB has certainly been a great community partner, and we thank them.
We all love our HEB in the state of Texas, don't we? It's the one thing we can all agree on. Except A&M is the better football team. Just kidding. We lost. So do we have a motion?
I would move that we approve issuance of a resolution acknowledging the executive director's acceptance of the gifts and donations contained in the TCEQ interoffice memorandum to the commissioners dated January 24, 2025, docket number 2024-1812-MIS.
Do a second.
Second.
All those in favor say aye.
Aye.
Aye. Thank you. Thank you, Jen. Appreciate it. I'll give everyone a second to get moving, but Mary, I think we're going through items 6 through 28.
That is correct. That takes us to our enforcement docket, which are items 6 through 28, and the executive director's staff is here to present these items.
Good morning, y'all.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 6 through 28. The total assessed administrative penalties are $863,496, with $37,506 deferred, $84,875 applied towards supplemental environmental projects, and $741,115 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Any questions right now? Do we have anyone signed up on these items?
We have people here who are available to answer questions on 8 and 10, but nobody who's asked to address the commission.
Garrett?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you so much. I very much appreciate it. Colleagues, I have a question regarding item 10. Given the seriousness of the violations and the resulting fatalities and hospitalizations, why was this not directed to the Attorney General?
Good morning, Chairwoman. For the record, my name is Amy Sedemeyer with the Enforcement Division. We did evaluate this case for potential referral to the Attorney General's office. Ultimately, it was decided to manage this case administratively at the agency. The respondent was fully engaged with us from the beginning on any and all corrective actions that are outlined in the order. The event itself was very short duration. No unified command was in place for this event because of the short duration. Although there were fatalities and injuries related, we did believe that we could and did achieve compliance with this and deterrence with our administrative order, with the penalty and the technical requirements laid out.
No, I thank you for that. And I do know that y'all are on it with ensuring that we are following our mission of ensuring public health. However, I'm prepared to move forward with items 6 through 9 and 11 through 28, but I would still like to prefer to see a serious violations such as those that result in life, in this case, 2 Texans, in 14 injuries, hospitalizations, referred to the Attorney General's office for civil enforcement. I take that oath and that mission seriously. I think it's important that these potentially receive a higher penalty and a court-ordered injunctive relief. For that reason, I would remand item 10 with the instruction to refer the matter to OAG immediately for the inclusion in their pending litigation regarding this facility. I'll stop here and ask my colleagues what they think.
Yes, ma'am. I'm in agreement. Well said. And I have one other question for staff now that I've heard a little more discussion, but I'll
Sure.
let
You
you
wanna
turn to
go ahead.
Commissioner. It's in another item, different
Oh,
matter.
absolutely. Okay.
I agree. Looking at the severe nature of these violations in this case involving 2 fatalities and 13 hospitalizations, along with the fact that the Office of the Attorney General has already commenced litigation against this respondent at the same facility, I think it would be prudent to remand this matter to the executive director to refer these violations to the Office of the Attorney General. So I'd also be in favor of adopting the other items as recommended, but sending item 10 back to the executive director for referral to the Attorney General.
Thank you, Commissioner. I just couldn't get past the 2 deaths. That is a very big deal, and we need to ensure that we are doing everything we can to make sure these incidents don't happen again. So appreciate the ED's sentiment, but let's send it on back if we can. Next, looking at the default shutdown orders, I thought it would be helpful to note that many opportunities that these entities have to come into compliance before the commission issues this type of order. I took a deep dive on that to make sure that that notice and that transparency was there before something like a shutdown order is issued. It is a very big deal to me. Entities receive notice through a notice of violation or enforcement. After failing to respond to this notice, the Office of Legal Services again provides written notice of the pending shutdown. And finally, if the entity is still not responding, the Office of Compliance and Enforcement will visit the facility to determine whether it has come into compliance. So there are multiple opportunities to work with the agency before we enter an order shutting these businesses down. Again, this is something we do not take lightly at the commission. I understand that these notices have been provided to these entities, and I'm prepared to move forward with these orders as I am with items 6 through 9 and 11 through 28 of the enforcement docket. And I will stop and ask Commissioner Janeka and Commissioner Gonzalez what they think.
I appreciate it. I had one question, and it's on the topic of item 8, matter 8 before us. I was just curious to ask ED staff if there was any consideration or discussion with this respondent under our SET program for consideration in addition to this item, whether y'all have any recollection or thoughts. And I just want to acknowledge, I appreciate that respondent being present today to speak. Hearing that, I felt a little better about asking ED, knowing they're here to further clarify and articulate if y'all aren't aware or can't speak to that discussion.
It's an excellent question.
For all of our enforcement cases, we do, it's part of our process to reach out to the respondent and ask them if they want to participate in our supplemental environmental program. It's also included in our cover letter. And then we've also, it is one of the selling points, one of the good things that we can advertise to. And so it is definitely part of our process. In this particular situation, I do not have any notes as to a particular conversation on that. But I
Thank
can
you.
look that up and get back to you.
I very much appreciate that. And hearing that, I wonder if we might ask Ethan Hines, who I believe is registered for this entity, if they may be able to come. I think you're virtually registered. So if we could unmute the public line. Mr. Hines, if you are present, if you could speak up, please. And if you have any information to better elucidate that point for us, I'd really be curious to know what extent the applicant, Afton Chemical Corporation, engaged or considered engaging with our agency in the SET program.
Can y'all hear me okay?
Very good, thank you.
Hi, thank you for letting me the opportunity to speak. So we actually have done the supplemental program in the past, and we were intending on doing it this time as well. However, during the discussion with the ED, it took a little bit longer for us to reach what we thought would be the final fine payment cost. So we unfortunately passed the deadline for submitting that. And we did reach out and ask if it was still possible to make that payment, and it was declined.
Okay, I appreciate that. And I do sincerely appreciate the extra clarity there. And I think that unfortunately doesn't land too far from the feedback I've heard elsewhere from how it is a thankless and added cost to navigate our dense regulatory process. And I think, not to tap dance too many across too many items, but encompassing our points about item 10, I'm pleased to hear that we were moving forward with an agreed order with the entity because of their engagement with us and being very forthcoming and willing to engage. I think that's always important for us to continue to meet the entities and applicants when they come at us with that attitude. Everything else about that item 10, indicated clear factors of regulatory competence. That's a intangible that I've noticed in many of the entities we deal with, and certainly participation in the SET program was one of those factors. So I'm in agreement with my colleagues about how we're happy with y'all meeting that applicant on item 10, but I think we do need to, considering the loss of life and injury, refer that on to the or to the Attorney General. Similarly on item 8, I'm satisfied hearing those extra details. I'm dismayed seeing the other details about the item that show this is a very competent entity that didn't participate in our SET program. But I think the public is getting a much better understanding of our agency's procedures and operations, and they're tuning in to that level of regulatory competence and where that engagement with our agency is what's helping permits move smoothly, or whether there's other intangible factors. And thank you for the discussion and the answers to that question, Mr. Hines.
Good. You good? Commissioner Gonzalez?
I can offer a motion if you're ready.
That would be great.
Okay.
Thank you.
I move that we remand item 10 to the Executive Director for referral to the Attorney General and adopt items 6 through 9 and 11 through 28 as recommended by the Executive Director.
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank y'all very much for your work on these. Appreciate it. All right, let's go to our rules, 29 through 30, please.
Good morning, Chairwoman, Commissioners, General Counsel.
I'm going to call
Oh.
the caption, sorry.
Sorry, Mary.
Item 29 is the consideration of the publication of and hearing on proposed amendments to 30 Chapter 321, new Chapter 321, Subchapter Q, Land Application of Dairy Waste Authority, and amendments to Chapter 335 regarding industrial solid waste and municipal hazardous waste. All of this to implement the 88th Legislature's House Bill 692. The Executive Director's staff is here to present this item.
Good morning again,
Morning.
Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Robert Sadler with the Water Quality Division. With me today is Greg Easley, also with the Water Quality Division. Also participating virtually are Joy Alabi with the Water Quality Division and Michael Parr with the Environmental Law Division. The proposed rulemaking implements changes to the Texas Health and Safety Code and the Texas Water Code made by House Bill 692 from the 88th regular legislative session. The proposed rules would amend Title 30 of Texas Administrative Code, Chapter 321, Subchapter B, to add new sections 321.48 and .49, which would allow dairy operators under emergency conditions to directly apply dairy waste to land application areas and dispose of dairy waste in a retention control structure, including a lagoon or playa, and irrigate land application areas with dairy waste from the retention control structure. The proposed rulemaking would also amend 30 TAC Subchapter 321 to add new Subchapter Q, Land Application of Dairy Waste Authority, which would allow entities to directly land apply dairy waste under emergency conditions on agricultural land that is not associated with an animal feeding operation or any other TCEQ authorization. Finally, the proposed rulemaking would exempt these activities from the permitting and notification requirements in 30 TAC Chapter 335. Staff respectfully requests your approval for the proposal of these revised rules. Thank you, and we are available to answer any questions.
Thank you so much. Any questions?
I have some questions.
Yes, ma'am.
Could you talk to me about the emergency conditions aspect of this? Because I didn't see that in the legislation.
Yeah. We worked pretty closely with stakeholders in industry on this rule, and our understanding of the intent based on those discussions is, and some background, is they sought this regulatory relief based on conditions they experienced during COVID and Winter Storm Uri and other similar events where they were unable to bring their product to market, and it resulted in waste. And so they're looking for the option to conduct this activity during those types of conditions. They have very few disposal options otherwise. And so that's why the emergency conditions were inserted into the rule.
Yeah, I understand the intent behind the bill. It's in the bill analysis. My concern is more that the text of the legislation does not say anything about emergency restrictions, yet the rule does.
Yeah, hi, good morning. Greg Easley with the Water Quality Division. I guess we felt that, absent inserting conditions as we have in this proposal, that it would potentially send a message, if you will, that, this type of disposal can be undertaken at any time, under any conditions. Granted, the industry, there's no incentive for them to do that or take advantage of that necessarily, but we wanted to put those type of guardrails on the proposed rules for those reasons.
Do you think that we could put it out for comment and see what stakeholders say?
I do believe there's value in moving forward with the publication and hearing on the proposed rules, but I do have significant concerns that we've gone outside the bounds of what the legislation has asked us to do, and that the proposed inclusion of the restrictions-based emergency conditions may not be consistent with the bill language. And I would like staff to investigate that further during this notice and comment period. And I would also propose the preamble for Chapter 321 expressly solicit public comment on the inclusion of the emergency conditions, definitions, and our restrictions. And I would direct staff to reach out to the authors of the legislation on that point.
I agree with that.
I'm enthusiastically in agreement as well. I believe that it is, in my opinion, I think it's an appropriate step into implementation that our agency undertakes in taking the statutory revision, but I sincerely appreciate Commissioner Gonzalez highlighting and suggesting that we direct more loudly to the public's attention that change to elicit substantive feedback. If there are concerns with that proposal, I believe it to be reasonable, but are there unforeseen circumstances that the participants under this proposed change in the rule and the stakeholders that started in that legislative process, naming those authors, I think is very important. And considering that the legislative session is now open, if our agency lacks the authority to articulate a clear go, no-go time or space that this activity is allowed, is licit, without overstepping the statutory bounds, I'm certain that the authors downtown, they hate to hear that they might need to file another bill. That's the worst news, I think, this time of the year, but that's a worthwhile discussion for us to be openly engaged in. I think Commissioner Gonzalez's recommendations would put us in the best posture to do so.
I agree, and I would say time is of the essence. We are in the middle of session right now, and the rulemaking has taken a while on this one. I guess there are many stakeholders with dairy waste. So let's get it going, and let's address all of Commissioner Gonzalez's issues and come to some finality on this. So you have your orders?
I have a motion if you.
Yes, let's hear it.
I move that we approve the publication of and hearing on the proposed amendments and additions to 30 Texas Administrative Code Chapters 321 and 335 as recommended by the Executive Director, with the addition of an express solicitation of public comment on the inclusion of an emergency conditions definition and restrictions.
Do I have a second?
I second.
All those in favor say aye.
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 Motion passes. Thank you for your work on that. Appreciate it. Thank y'all very much. All right, let's go to the next rule. Item 30, please.
Item 30 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 210, Use of Reclaimed Water, and Chapter 321, Control of Certain Activities by Rule. The Executive Director staff is here to present this item.
Good morning, Chairwoman.
Again.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Robert Sadler with the Water Quality Division. With me today virtually is Michael Parr with the Environmental Law Division. Rulemaking being considered for adoption implements changes to the Texas Water Code made by Senate Bill 1289 from the 88th legislative session. The rules, if adopted, will amend Title 30 of the Texas Administrative Code, Chapter 321, Subchapter P, to allow owners of reclaimed water production facilities an alternative means of disposing unused domestic reclaimed water through the collection system of an associated wastewater treatment facility. To do this, owners of reclaimed water production facilities must obtain consent from the owners and operators of the associated wastewater treatment facility and collection system. The rules, if adopted, will also amend 30 TAC Chapter 210, Subchapter A to clarify regulatory citations associated with the general provisions of the use of reclaimed water. Staff in the Water Quality Division initiated the rule text revisions to implement the Texas Water Code statutory changes made by the Senate bill, and we included additional revisions necessary to improve clarity and ensure readability of the revised rules. These revisions were published in the October 11th, 2024 issue of the Texas Register. The Commission held a hybrid public hearing on November 12th, 2024, and the 30-day public comment period closed on the same day. Public comments were received from 3 entities. Minor changes were made in response, and these changes are included in the proposed text you are considering for adoption. Staff respectfully requests your approval of the adoption of these revised rules. Thank you, and I'm available for questions.
Thank you so much. Any questions? Is anyone signed up for this item?
No one has signed up.
OPIC?
OPIC has reviewed this rulemaking and we support adoption. We recognize that an increase in reclaimed water could grow the water supply in Texas, particularly during times of high demand, and hopefully lead to lower water costs for all Texans. Regarding public participation, we note that the public involvement plan and alternative language requirements were met, and a hybrid public hearing was held November 12th, 2024. 3 public comments were received, including 1 in support of the rulemaking, and some non-substantive changes were made to correct noted errors. Other recommendations were not incorporated because they were outside the limited scope of this legislative implementation project. In conclusion, we appreciate staff's work on these rules, and we believe they are well drafted to implement Senate Bill 1289. We support adoption. Thank you.
Thank you, Garrett. Well, nothing says romance like an agenda chock full of dairy waste, reclaimed water, and discharge. But thank you for that summary. And OPIC, thank you for your input. I reviewed this rule package, including the comments that we received for the public and the executive director's edits to the rules. And I believe that this is an appropriate rulemaking as it implements legislative direction that we have received. I'm ready to move forward and adopt these rules. Commissioners?
I'm in agreement.
Also in agreement.
I move that we adopt the amendments to 30 Texas Administrative Code Chapters 210 and 321 as recommended by the Executive Director.
Second?
All those in favor say aye.
Aye.
The motion passes. Thank y'all. All right, Mary, item 31, please.
That brings us to our public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with the Water Code Section 5.112. The commission cannot hear comment on pending permit matters or other contested cases such as enforcement matters. Those are subject to an ex parte prohibition found in Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with a total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given is limited to statements of specific factual responses and recitation of existing policy. And with that, I'll begin to call commenters. First, we have Errol Summerlin. I believe he's appearing virtually.
Mr. Summerlin?
Yes, commissioners. Good morning. My name is Errol Summerlin, and after living in Portland, Texas for 40 years, I now reside in Salisbury, Maryland. However, I'm very much involved still in the Coastal Alliance to Protect Our Environment in the Coastal Bend of Texas, and I'm co-founder of that organization. You know, in my comment today, I actually had a difficult time working with the rules as recited by the general counsel just now about ex parte communications. During the process of a particular permit, I submitted public comments, written public comments, both on at general public meeting as well as after the executive director's draft report. And what I wanted to do today is highlight some of the comments that I made in that process about the Hillcrest Residents Association and how they should be granted a contested case on the Inner Harbor desalination permit that will be coming before you next month. And I'm curious as to whether or not I am able to read and highlight some of those comments that I made.
Mr. Summerlin,
yes,
you won't be able to do that because there wasn't notice that this matter would be discussed at this meeting, and all parties don't have the opportunity to come here and comment on that. This is just a public comment session, and so that would not be allowed.
Well, now I don't want to spar with you on it, but I'm curious because my comments are a matter of public record, okay? Which
and the statute doesn't require or doesn't allow the commission to be addressed if it's not been noticed to the public. And so the public hasn't been noticed, or I'm sorry, noticed to the public, the applicant, et cetera, and they don't have the opportunity to be here today.
Well, I took a look at your at 2001.061 Texas Government Code, and it says a member or employee of a state agency assigned to render a decision or make findings of fact and conclusions of law in a contested case may not directly or indirectly communicate in connection with an issue of fact or law with a state agency person, etc. Now, it's my understanding, and you stated just a moment ago, that any comments that we make, y'all can't comment on. Y'all can't communicate with us at all on it. So you're not really communicating. You're only listening to me, and you're not communicating with me on the matter. You just thank me for my comment, and that's the conclusion of it. So I don't really understand. Can you explain a little bit more about why?
Sure, Mr. Summerlin, this is Chairwoman Pop. While I very much appreciate your passion and your willingness to address the board, the other parties are not here at the moment, so it would be improper for the commission to hear solely your comments. Again, I do appreciate that you are so passionate about the issue, but there will come a time when the commission can hear from you, and that time will be appropriate. You do not want to hurt your case moving forward.
Yeah, Madam Chair, may I? That's precisely the point I wanted to make, and I appreciate you raising it there at the very end. Mr. Summerlin, as the single non-attorney on this distinguished panel before you, in my view, it simply makes a stronger case for the parties representing the applicant that you want to speak against. And so if you want to take your time, limited time today to speak before us and improve the case of the other parties, I so was expecting to hear your usually eloquent and colorful advocacy for our state today. And I think that this would be replayed and used in a much different and harmful context from your view, in my personal opinion. And that's the primary reason that the attorneys and counsel provided here find a good conservative reading of the ex parte provisions before us, and why we discourage you strenuously from raising any more specific pointed discussion commentary about any particular entity for fear of that entity coming back in court before us or elsewhere, before another court. You don't want to make them look better before another judge. I believe. Thank you for your
Well, that
engagement.
that was really good, Commissioner Chan. I appreciate that. You know, I think it deserves some clarification for members of the public as to why they're not allowed to do this. And I want to thank you. I know I probably extended my 3 minutes here by asking this question, having this colloquy with you, but I do appreciate the information, and I'll just end with thanking you for your time.
Well, thank you. I very much appreciate it, and we will see you at a later point.
Okay, our next commenter is Jason Hale.
Jason,
Yes, can you hear me?
we can.
Awesome. Good morning, Chairwoman. Good morning, Commissioners. Thank you for taking comments. My name is Jason, and I live in Corpus Christi. Today, I wanted to talk about the health of Texas estuaries. So as you know, one of the defining features of Texas is its chain of barrier islands that are home to 6 out of 7 of our estuaries. While these islands are part of what makes Texas special, they also come with their own set of challenges that require stewardship in order to protect the fisheries and ecosystems they enable. Back in 2022, our local estuaries program released a study on this topic titled Vulnerability Assessment of Coastal Bend Bays. The study looked at the effects of salinity on the diversity and abundance of economically important species within the Corpus Christi Bay system, and found that increases in salinity will add pressure to a system that is already stressed. Now, there are multiple reasons as to why the bay system is salinity stressed. One of them is long-term increase in temperature that increases evaporation. Another is reduced freshwater inflows from drought and high diversions. But for me, the most interesting or unique contributor to this condition is the sluggish circulation in the bay due to the barrier islands. The bay here is almost completely blocked off from the ocean with the exception of 2 narrow passes, making it sensitive to changes in waterborne materials that are easily concentrated by high evaporation rates and are hard to disperse because of low flushing rates. So because of these factors, average salinity is 25% higher than the optimal salinity. And as I mentioned earlier, increases beyond the optimal range, reduces species diversity and abundance. Okay, so why does this matter, right? I believe all of the barrier island estuaries in Texas face similar challenges to a lesser or higher degree. And I'm asking that they receive careful consideration when looking at projects that will alter their salinity. From what I can tell, most assessments use simple one-dimensional models like Qualtex or mass balance, which assumes the waste load is evenly mixed across the system. To me, that's kind of like saying the emissions from a refinery are evenly distributed across an airshed once it leaves the property line. Anyways, these are probably fine for small scale discharges, but for something large scale, it is concerning that better modeling tools are used. With that in mind, I urge you to consider requiring 3D hydrodynamic mixing models for high volume hypersaline waste loads that are discharged into Texan estuaries. And that's my comment. Thanks.
Thank you, Jason. I very much appreciate your comment. Mary?
And our final public commenter is Kathy Fulton.
Kathy? Ms. Fulton, are you there?
Yes. Hello?
I can hear you.
Oh, okay. Hi. Good morning. Good morning, Chairwoman, and to the commissioners. And yes, I would like to make a generalized comment about seawater desalination. And
Yes,
what I
ma'am.
would like, is that okay?
Yes, ma'am.
Okay, and what I'd like to refer to here is House Bill 2031 that was approved by or enacted by the 84th Texas Legislature. And so in September 1st of 2018, there was a study released, the Marine Seawater Desalination Diversion and Discharge Zone Study. And essentially discharge areas and diversion areas in the Gulf, into the Gulf of Mexico along the Texas coastline. And this study and the rural matter was approved and adopted by TCEQ at the November 6th, 2019 meeting as part of the TCEQ program for expedited permits concerning seawater desalination. And in that study, what is very good about this study, and I know many of the scientists that participated in this study, they put these areas that for discharge, for intake or discharge in along certain areas of the Gulf that I call the green zones. And you can see those in the mapping on those studies. And these green zones, because they've been studied more, they are considered to be hopefully the better locations, especially for discharge. And this matters because right now, no seawater desal application has attempted to try to hit one of these zones. In fact, there's been no expedited permits submitted thus far. And I would encourage, just as a previous speaker, Jason, noted about the Corpus Christi Bay system, I believe that the Corpus Christi Bay system is takes about 1.3 years to fully circulate in and out of the water in and out of there. And that's why the salinity factors and other factors about discharge are so critical, because when you're talking about large volume brine discharge into essentially closed bay systems, there's just no way it's not going to affect the salinity levels over time. And I would just encourage this commission to please consider or somehow motivate applicants to try to go for these green zones, these discharge areas along the Texas coast that have been studied, have better circulation, and aren't into a closed bay system and don't threaten the marine life and structures. As you, Port Aransas is one of these areas. We know Redfish Bay is vital. It's a vital nursery. And if we don't get those little babies to grow up there, they don't get out to the rest of the bay system. And so I would hope that you will just take this into consideration and review that study to further, understand it. And that's all I have. Thank you very much for your time.
Thank you so much for participating today and your comments. Anyone else?
Nope, that was our final commenter. So that brings us to our items for executive session, items 32 through 35. The commission will meet in closed session in room 242 of the Texas Workforce Commission at, I'm going to say 10:45. I think it's 10 minutes.
Yes, ma'am.
10:45 as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074, to take up and consider matters pursuant to items numbered 32 through 35 as posted and noticed.
This meeting stands in recess. Thank you.
The commission met in room 242 of the Texas Workforce Commission for closed session from 10:50 a.m. until 11:25 a.m. on item number 32, as posted in notice pursuant to Texas Government Code, Section 551074. No action was taken. The agenda stands adjourned and the time is 11:31.